Good afternoon, everyone. Myself Twinkle Mahajan from Khalsa College of Law, Amritsar, and today I am here to discuss a very important topic regarding arrest under Bharatiya Nagrik Suraksha Samhita 2023. So I have got my guest today with me, Advocate Gurpreet Singh Pavalji. Sashrikal sir.
ਸਤਿ ਸ਼੍ਰੀ ਅਕਾਲ ਜੀ।
ਸਰ ਅਰੈਸਟ ਦੇ ਟੌਪਿਕ ਦੇ ਵਿੱਚ ਬਹੁਤ ਸੇ ਸਟੂਡੈਂਟਸ ਨੂੰ ਬਹੁਤ ਜ਼ਿਆਦਾ ਡਾਊਟਸ ਨੇ so I want you to clarify each and every doubt of our students as well as our audience.
Sure.
Thank you, sir. Sir, how person is arrested?
There is a legal procedure provided under the BNSS as per section 36 and as per section 43 of the BNSS. A person is arrested. Police officer is bound to prepare the memorandum of arrest while taking the person into custody, and there are other formalities also which are required to be followed by the police officer arresting a person.
All right, sir. Sir, how important in arrest memo in court?
Arrest memo is an important document in court because in arrest memo there is mentioning of arrest of the accused and time and place of arrest of the accused. So after arrest, many rights of the accused are operated. So arrest memo is a very important document. It is exhibited also during trial by the public prosecutor.
All right, sir. Sir, who has power to arrest?
As per Bharatiya Nagrik Suraksha Samhita, police officer can arrest accused or any other person with or without warrant, as the case may be. Similarly, magistrate, executive, or judicial, they are having the power to arrest. Further, private person is also empowered under the BNSS to cause arrest under special circumstances.
Sir, sir, how do court balance personal liberty and investigation under BNSS?
I would like to appreciate this question. Very good question. So, personal liberty is a fundamental right enshrined under Article 21 of the Indian Constitution. So, as far as balance between the investigation and personal liberty is concerned, let me make it clear fundamental rights are not absolute. There are certain restrictions imposed. Police requires the custody of the accused, then definitely his personal liberty can be sacrificed for that purpose only. Once the investigation is complete, police is satisfied, then the accused may be sent to the judicial custody, or he or she may be granted bail by the court also, as the case may be.
Okay, sir. Sir, can you please tell us the difference between arrest and custody?
Listen, in all arrest there is custody, but vice versa is not true. So custody, you may say, is a initial process by taking into custody any person which the police officer want to arrest. So it may be defined as physical restraint.
Okay.
So which is a physical legal restraint where personal liberty of that person is jeopardized. But as far as arrest is concerned, in arrest there is formal procedure to be followed. So custody is more physical and arrest is more procedural. So memorandum of arrest has to be made.
All right, sir. Sir, what are the initial rights immediately after the arrest?
Another very informative question. This is going to be an informative answer. So initial rights after arrest, there is a right to be informed regarding ground of arrest. So it is a duty of the police officer arresting the person to inform the arrested person regarding the grounds of arrest. He should also inform him that whether the offense is bailable or non-bailable. In case of bailable offense, police can grant the bail to that person. Then there is a right for medical examination. Then law is providing that there should be no unnecessary restraint of the arrested person. Similarly, any relative of the arrested person must be informed regarding his or her arrest. So there are number of other rights also. So that arrested person should not be detained in police custody without the permission of the magistrate for more than 24 hours as per section 58 of the BNSS. So these are rights of arrested person immediately after the arrest.
Sir, can you please tell something about remand documents?
Remand documents. So let me tell you, whenever a person is arrested, so as per section 58 of the BNSS, So that person must be produced before the nearest judicial magistrate within the period of 24 hours. And when that person is produced before the magistrate, in case of bailable offense, he or she may be granted bail. And in case police requires his custody for the purpose of interrogation, the magistrate is empowered to pass the order of remand, sending the accused to the police remand, and in other case, sending the accused to the judicial remand in judicial custody in jail. So, whenever the remand is going on, this remand goes on during the period till the period the challan is presented. So before the presentation of the challan, the remand period is going on, and the police presents the document before the court for the purpose of seeking the remand is known as remand documents. So what it is included in the remand document? There may be FIR, there may be the application of the police by which they are seeking the remand. There may be a statement of the witnesses under section 161 CRPC or now under 180 of the BNSS. So there are certain other documents which are produced by the police before the Ilaka magistrate. But once the charge sheet is filed, these remand documents, these remand papers come to an end.
Sir, can violation of arrest rights under BNSS be a ground for a bail?
Definitely. So arrest has to be made as per the procedure prescribed under the BNSS. In case of violation, that may afford the ground to the accused to be released on bail. Definitely.
Alright, sir. Sir, procedure of arresting male and female is same or not?
There is a slight difference. So police can use force in order to arrest a male culprit. But on the other hand, police has no power to use force in case they want to arrest female culprit. Her submission may be presumed as per section 43 of the BNSS. Moreover, male can be arrested during day or during night, but female cannot be arrested after sunset before sunrise unless there are special circumstances. Female officer applying to the Ilaka magistrate and seeking the order of arrest of the female during night. In that eventuality, she may arrest. But otherwise, there is no power with the police to arrest the female accused during night.
Alright, sir. Sir, can you please tell us who is juvenile? What does the term juvenile describes?
We may use the term juvenile or we may use the term child in conflict with law.
Alright.
Juvenile Justice Care and Protection Act 2015 is providing something about that. A person who has committed the crime and who has not completed the age of 18 years may be termed as juvenile. So, as far as juvenile is concerned, juvenile is not sent to the police lockup or jail. Juvenile is sent to the observation homes. Observation homes are there in Hoshiarpur, in Punjab, in Ludhiana, and for girls it is in Jalandhar, I think. So these are children who have committed the crime. So they are kept separate from the hardcore criminals. So that's why they are not sent to the jail.
Sir, how they are arrested and what is the procedure for arresting them? Any certain?
We don't use the word arrest for the purpose of juvenile, we use the word apprehension.
Alright.
So once the juvenile is apprehended, he or she may be apprehended by the Special Juvenile Police Unit or Child Protection Officer, and they may be produced before the Juvenile Justice Board. Then all the orders are passed by the Juvenile Justice Board with regard to custody or release of that juvenile.
Alright, sir. Sir, one last question. Sir, what skills should I focus on to grow into a competent and effective litigator, according to you?
So these days, students are not inclined in practice. They want to clear the competitive exam. But recently, our Honorable Supreme Court has held that 3 years practical experience is required for the purpose of appearing in judicial exams. So I advise all the students watching this video that learn the practical skills from the court and thereafter give time to the books also. So book reading is essential, but at the same time, gaining practical knowledge is also mandatory. So join some advocate in the court learn the practical skills, learn the art of cross examination and argument, and at the same time maintain a balance between your practical knowledge and your theory preparation. So this is my advice to all the students. In this way you may become competent to clear the competitive exam.
So thank you so much. It's a great experience. Hope you like this video. This is more informative for the audience. Thank you so much.
Thank you everyone, thank you so much, thank you.